Matthew, did PIA think there should be a regulation mandating disclosure?
Absolutely not. Mary, we've never thought there's been any justification for the adoption of a regulation mandating producer compensation disclosure on behalf of independent Main Street insurance agents. It's simply a solution in search of a problem. But we thought it was important for us to stay at the table, to work with the department, and we've achieved vast improvements in the ultimate draft that was promulgated. We still don't like it, and we're still opposed to the promulgation. However, it's better now than it was in the beginning.
What has PIA accomplished?
We've accomplished a number of things. The original premise of the regulation was to make contingency legal. We're proud to say now that we've taken that out of the draft. We've exempted renewals. We've taken out any proscription in terms of form and language for compliance levels. We've made the process simpler overall for the agents in terms of compliance.
So if PIA disagrees with the regulation, why didn't it join a lawsuit against it?
That's a good question, Mary, and one that we did not answer quickly or prematurely. We consulted with our volunteers, we consulted with Article 78 litigation attorneys. We've explored a number of options prior to actually making that decision as an association. Our Article 78 attorneys told us that the chances of success on an Article 78 were slim to none. They also told us that lending your name to an Article 78 that already exists out there does not in any way appreciably increase the chances of ultimate success in the courts. And on the other hand, the department has told us that to the extent that we sued, or we said we were going to sue, we would be closed out of continued negotiations and crafting the compliance documents. We think there's a considerable amount of work that still needs to be done, and therefore we made the decision to continue to work on this.
But the regulation's already been finalized, so what is it that we're looking to achieve at this point?
The regulation has been finalized. However, it will not go into effect until January 1st of 2011. There's a significant amount of time between now and then, and I think it's an illustration on the part of the department, and certainly on the part of associations out there, of the amount of work that we need to do on this thing. We need to give our producers clear guidance, clear language, and approved forms, so that when this thing does drop in their laps on January 1st of 2011, they are fully confident in their ability to comply with this thing. If, on the other hand, we did not do these circular letters, and we did not work with the department in drafting these compliance documents, and ultimately we did not answer the questions, the hundreds of questions that our producers have with respect to how they're going to do this thing, they would be in a very uncomfortable position when this thing ultimately hits.
So what can agents do to help?
Well, agents can do what they've continued to do all the way through this process and have done for years, and that is to share with me and to share with us their opinions on this. Tell me where the problems are. As we go through and work with the department on compliance, really what we're focusing on is the nuts and bolts about how you as an agent are going to comply with the department's regulation when it's dropped on January 1st. I need you to start thinking about that as an agent. I need you to start thinking about where the problems are, and then pick up the phone or fire an email off to me on your computer and say, geez, you know, this is a particular problem. It would help if you would answer this question, and we will bring that question to the department and get it answered for you.
And so the phone number and email address are?
Phone number is easy. It's 1-800-424-4244, and our email address, as always, is govaffairs@pia.org.
Thanks, Matthew.
Thank you.